So Lauren, Maya, oh, all right, we're live. Thank you so much for joining us, Steve and James, and all the folks who are tuning in. I think we were at about 200 yesterday, so it is an exciting and well-attended event. Thank you so much again for your time. I have been really enjoying getting to set a few days aside to read your book, The Fear of Too Much Justice. And I'm so grateful for your time today, in particular because of your work with the Southern Center for Human Rights, in addition to your work as legal scholars advancing ideas for the improvement of the criminal justice system, as well as directly improving outcomes in the criminal justice system. I'm Rebecca Buckwalter-Poza. I'm the Senior Fellow at Alliance for Justice, which is an association of more than 130 organizations around the country committed to building power, transforming courts, and securing justice for all. And today's conversation, of course, is part of our Holding Court series, which Holding Court, Justice Conversations with AFJ. We've been fortunate to be able to feature leading scholars, activists, and attorneys to discuss current political and social justice issues. And we are honored to have you as the latest guests for this event. Thank you both so much. And how are you doing today?
Thank you for having us.
Thanks for having us. It's a real pleasure to be here. It's good to see you again, Rebecca.
Good to see you.
It's great to be here. I was involved with the Alliance for Justice well over 30 years ago, trying to keep Ed Carnes off the 11th Circuit. I did a great deal of work with Nan Aaron back in those days. So my affiliation with the Alliance for Justice goes way back.
We did just celebrate our 45th anniversary. Nan Aaron, who founded Alliance for Justice and served for 42 years as its first executive director. And I'll take this moment to remind the audience that you are free and encouraged to submit questions at any time into the chat. And our wonderful membership and outreach colleagues will be queuing them up for us as part of a continuation of the conversation. Not, of course, that I expect we will run short on topics. So the full title of your book, The Fear of Too Much Justice, Race, Poverty, and the Persistence of Inequality in the Criminal Courts, is about, hopefully, not just the shortcomings of our current justice system, but the future of justice in America, particularly with respect to criminal justice. I will just briefly share. So the title of the book refers to the fear of doing too much justice and how it has generated misguided policies and rulings, including at the Supreme Court, that undermine equal justice under the law. And so we'll get into it, but specifically you discuss how the criminal justice system is disproportionately targeted marginalized communities, individuals within them, and contributed to the rise of mass incarceration, further compounding the inequalities that pre-exist and contribute to who is targeted by the criminal justice system. And you refer to the fear of too much justice as an obsession with retribution, and how this trend has caused the erosion of due process protections and the criminalization of conditions like poverty, mental illness, and racial and socioeconomic disparities broadly. And you touch on judicial activism and overreach, which I would love to spend more time on, and how this fear has led to a narrowing of protections and to the corrosion of democratic principles themselves. So thank you again so much for joining. And a reminder to all that a recording of our conversation will be available after the event. With that, I've got a bunch of sticky notes, which somehow got me through law school and the bar. So So Dan, you talk about how pleas feature in a lot of injustices within the legal system in the United States. And so I'd love to start with that, because I think that, and I'd also love to get to law and order politics, but for most people, lawyers and the public, pleas as they're presented in popular media are very different from the reality that you describe. So if you would expand on that, that would be fantastic.
Well, sure. One of the things we talk about are just the tremendous power that prosecutors have to decide what to charge, when to charge, whether to resolve cases and plea bargains. And we give examples of a couple of women sentenced to death in Georgia. Both cases, the plea offer to both the woman and the co-defendant in the case, which was in one case the lover, in the other case the husband, they could testify against each other or plead guilty and get life in prison. But if they didn't, they faced the death penalty. Both women went to trial, both got the death penalty. And in Tiffany Moss's trial, the prosecutor said in closing argument, there's some crimes that are just so terrible that the only proper punishment is the death penalty. And the jury gave the death penalty. Of course, he knew better. He had been more than happy to resolve the case with a plea bargain and life in prison. The only reason that Tiffany Moss got the death penalty was she didn't take the plea. And I think many people don't realize that a lot of the people serving death sentences and serving the most severe prison sentences are not there because they committed the worst crime or they're the most incorrigible offender, but because they didn't take the plea offer. And because they happened to land in a prosecutorial district where you had a prosecutor who very vehemently sought the death penalty, as opposed to another judicial district where maybe the prosecutor never sought the death penalty at all. So that's a tremendous amount of power. That's not reviewed by any court. That's totally up to the prosecutor, the elected district attorney. In almost every state, prosecutors are elected, few not, but mostly.
And so Steve talked about how pleas work in the most high stakes cases and death penalty cases. As you mentioned, Rebecca, if you watch TV, you get a certain sense of how plea bargains are supposed to work. Often you have, a plucky defense lawyer who's negotiating with a prosecutor. One thing we talk about in the book is that the vast majority, if you count them, the vast majority of plea agreements are made by defendants who essentially have no lawyer or barely have a lawyer. So in many jurisdictions, they will have days, basically jail clearing days when people will be brought from the jail to the courthouse in large numbers, and they will be advised by a lawyer for a few seconds who will essentially say, this is what the deal is. And then they will essentially plead guilty en masse. So plea bargains are a powerful tool, or plea negotiations, a powerful tool for prosecutors, again, both in the highest stakes cases and also in routine cases. And this is why, I think the popular image of the criminal legal system is that you have an adversary system between a prosecutor and a defense attorney, they go to trial, they put on evidence, but in fact, more than 90% of cases in both the state and federal systems are resolved with plea bargains. And again, one of the fundamental problems is that in many cases, the defendant does not effectively have the assistance of a zealous, committed, capable lawyer. Rebecca, you might be on mute.
Pardon me, I'm plagued by technical difficulties here in DC. Stephen, one of the cases that you allude to in Georgia, the defendant, Tiffany Moss, she didn't even speak. She didn't have counsel. She turned it down. She was technically pro se, but didn't actually have the assistance of counsel until the appellate stage, right?
This is a tragic case. I mean, if she had not landed in this she was in Gwinnett County. Prosecutor there is one of the people who sought the death penalty most frequently among prosecutors in Georgia. This young woman who had some brain damage just sat there through the whole time. She didn't have a lawyer. The judge wouldn't even have a lawyer. The Supreme Court has said you can have a lawyer advise the person even if they're not formally the lawyer. And also, even in some cases, a case out of Indiana, the court had said if it's necessary for justice, the court can even appoint a lawyer. But this judge wouldn't do anything. kept telling the lady very nicely, I'll be glad to help you anything you want me to do. But basically, she sat there during jury selection, didn't say a word. She didn't give an opening statement, a closing argument. She didn't examine any witness. She just sat there. It's this young, fairly small of stature, African-American woman sitting there with her arms folded while the two prosecutors tried the case like they're trying the trial of the century. And they're telling the jury, you got to give this woman the death penalty. And the crime was so terrible and it can only be punished by death. Nobody had been sentenced to death in Georgia for 5 years. So this is the one death sentence that was imposed, and I don't think anybody's been sentenced since. So in about an 8-year period, the only person sentenced to death in Georgia is not sentenced to death because of the crime. It's because of her really incompetence for trial, her just sitting there during the trial, and the prosecutors just having a field day going after her.
And that gets to, it seems like the standards both for who is eligible to stand trial and for the performance of the attorney when there is an attorney between the defendant and the jury or the judge, that these standards are really just far too low.
Yeah, I think one thing that, as Steve said, the number of death sentences being handed down in Georgia is far down from what it was in the late 1990s. This is true across the country. The shift has been dramatic in places like Virginia, Virginia, I think, is third maybe in states that have executed the most people. And why did this happen in Virginia? It happened because the state funded a group of public defender's offices that were dedicated to capital cases. Because what we found, what I think this is well known in the death penalty community, if you have capable defense attorneys who are well funded, have access to the investigators and the experts that they need, it's extremely difficult for the prosecution to obtain a death sentence. And what happened in Virginia is essentially they had very few or no death sentences for a long time until the legislature said, why do we even have the death sentence? And they repealed it finally. And I say this because, Steve said, when we think about who gets the death penalty, Steve said, it's people who land in a jurisdiction with a particularly, let's say, zealous district attorney. It's people who make bad decisions when they're offered plea bargains. And it's often people who don't have access to competent defense attorneys because, kind of the underlying problem here is that the systems for public defense have been left up to the states, and the states have often left it up to city, municipalities, and counties. So there is a patchwork of public defender systems, and they range from excellent to non-existent. And so again, if you look at, if the goal is equal justice for all, the factors that affect the justice you get, I think anybody would say are arbitrary. One of them, frankly, is geography. That's just a major factor, and that's because geography often determines what kind of representation you end up getting.
Yeah, in fact, I just say on that point of geography, if that case that we've been talking about, Tiffany Moss, came into that Gwinnett County today, it's a different prosecutor. He lost when he ran for re-election the last go-round, so it wouldn't even be a death case today. It really is. One time there was a case in South Carolina where if it was in one county, Lexington County, is going to be a death case, and it was Columbia County, it would not be. And they had to survey where the crime took place to see which side of the county line it was on. And it turned out it was unfortunately for the defendant, it was on the Lexington side of the line. So it ended up being a death case where if it had been a few feet over, it would not have been. So we say it's a matter of race and place, who gets the death penalty.
And it's a matter of timing too, right? So one of the things I've found very interesting is there were 4 states, and this is no longer true as of 2017, but where judges could override juries and impose the death penalty on a defendant. And although that hasn't been the case since 2017, there are still 35 people who are on death row, who are awaiting execution, who today or at any time after 2017, the judge couldn't have overridden the jury. And you've included several examples like that of trends and changes, but they're not, backward looking. There's no retroactive component to some of these reforms. And so I was curious about that, if you had suggestions.
Yeah, there are a couple of interesting issues you raise. I mean, one is just the issue of judicial overrides. So, as you said, there are 4 states when the jury essentially would make a recommendation, and then the judge could decide whether or not to sentence somebody to death. And what you find if you look at those states is that in all of them, with the possible exception of Delaware, it was not so pronounced, but in all of the other ones, the overrides were overwhelmingly in favor of death. So, in theory, the judge could go either way. He could take a recommendation of death and change it to life, but overwhelmingly, the changes were made from life to death. And that is clearly related to the fact that we elect most of our trial judges in most of our states in the country, and the dynamics of judicial elections are such that it's shall we just say it's much better from an electoral standpoint to be seen as being tough on crime than being soft on crime. The other issue you bring up is the issue of retroactivity. I think one of the good things is that, as I said, the number of death sentences is down significantly, and the overall trend in death penalty related legislation is certainly positive. The number of states with the death penalty on the books is going down. The number that have an effective death penalty in the sense that they actually use it is going down. These are positive trends. As you said, often these changes are not made retroactively. We went to law school in Connecticut, where Steve teaches. In Connecticut, when the death penalty was repealed, it was explicitly not made retroactive. And the reason was, essentially, there had been one horrific crime that had happened a few years before, and the legislators essentially could not bring themselves to vote for a bill that would have let these 2 defendants off of death row. And then, as I'm sure you know, the Supreme Court decided that it was unconstitutional to have a non-retroactive death penalty. So Connecticut's
the Connecticut Supreme Court.
So Connecticut Supreme Court, sorry. But I think that it's often, even in a time of slowly improving legislative sentiment, it is often difficult when you have the facts of a specific case. It's difficult for for legislatures to be seen as being soft on particular people.
And so that, right, you're alluding to the sort of law and order politics, which of course there's been, it seems, a resurgence of very explicit iterations of law and order politics. One of the underlying concepts that you get to that I think people don't necessarily think about with respect to legal education or to the justice system, but how do we explicitly tap into and improve our capacity for compassion, and how that plays into the justice system?
Well, I think part of that is what people are exposed to when they're in law school and where people go. Of course, we don't need to get in a long discussion of the fact there's a lot of money to be made practicing law, rearranging the assets of the upper 1%. And a lot of people opt for that. And of course, if you do, you don't really see Tiffany Moss or
Right.
Kelly Gissendan or some of these other people and see these sort of vulnerabilities and what people have been through. And I think, more and more, there's just a need for people to be in the field. As James pointed out a moment ago, when you actually give juries some sense of the humanity of the people facing the death penalty, and when you look at all the hills and valleys of their lives and all they've been through, it's very, very difficult, I think, at the end of the day for people to decide to just make a premeditated decision to decide somebody ought to die. But if you don't ever have the information, then it's never going to happen. And I just think that there's, a really important need in the law schools and out afterwards to get people in the field and dealing with people who are facing criminal charges, because there are just so many people. And as we've talked about, from the lowest end, people that just get arrested on garden variety misdemeanor cases, but come into court and you have what James described earlier, the meet them and plead them. They plead guilty because they got to get out. You're in jail. Well, you plead guilty today, we'll let you out. So you're going to plead guilty whether you're innocent or not, because you don't want to come back in 6 months for a trial. You're only going to get 6 months. So there's a lot of just processing people through the system instead of really giving people the sort of individual representation that as individuals that they're entitled to.
Yeah, I'd like to add, I think that, one of the fundamental problems is that I think that there's a prevailing sense that injustices in the criminal legal system, while they may exist, happen to other people. And obviously not everybody has that belief, but I think that it's a way for people to categorize what they hear about the legal system. I will say that, I think that one of the positive trends in past 20 years has been due to essentially the innocence movement, right? Because the, DNA exonerations have an emotional pull on people that failures of due process do not typically. And there have been so many well-documented cases that I think that has made people think that the criminal legal system is not infallible, first of all. And I think that is one of the reasons why, at least on some issues such as the death penalty, the political trend has been modestly positive. I think that this is just a little side note. I think that there has been an increase in kind of independent reporting on criminal legal system issues. There have been podcasts like the story of Curtis Flowers, I think was extremely widely followed. And I think that, anything that can be done to humanize the challenges that the system is creating for people is a benefit. I have to say, unfortunately, that, consumption of media is largely, what media someone consumes is very much a product of who they are to begin with. But I do think that, certainly at least in some groups, there is increasing consciousness of the systemic unfairnesses that afflict the criminal legal system.
And Charlotte Dewan had a piece in the New York Times just within the last week or so about this attorney general in Missouri, who the three different people who are innocent, two found innocent by judges. One, the district attorney in St. Louis County has moved to set aside a conviction and because the person is innocent. The district attorney, this is not the defense lawyer, this is the district attorney, has decided the person's innocent, and the attorney general is trying to execute that person, and even tried to intervene to prevent the trial court from having a hearing on whether he was innocent or not. What is going on here? One thing that we point out is that the system is failing in the most fundamental responsibility that it has, which is to separate the guilty from the innocent. And it's troubling that we see in Texas right now, Robert Robertson, shaken baby syndrome case. Almost clearly the man is not guilty. But they thought he didn't react appropriately when his baby died. Of course, he was on the spectrum. He was on the autism spectrum, and they didn't understand that. And yet he's got an October date, and the Attorney General of the powers that be in Texas want to execute him. To Forrest Johnson in Alabama, innocent. And yet the Attorney General is doubling down on trying to get him executed. And so these innocent cases aren't just a once in a lifetime kind of cases. Here are a whole bunch of cases going on right now in the courts in Alabama, Texas, Missouri, where the question of whether people are going to be executed in the next several months are innocent or not. That's not good.
And shaken baby syndrome, that's also an example of sort of a popular notion that upon further scrutiny isn't really what it was presented to be, right? Not necessarily something where there's a bright line or that's a clear objective instance. And another example, just blood spatter analysis. Pam Coliff wrote that stunning series for Texas Monthly, having attended these classes. And this was presented, is still presented on television and all these different mediums as unshakable scientific proof or forensic odontology. And so I was curious about what you think might be able to be done to sort of fact check that, or how important you think it is how these ideas are presented to the public versus how they play out in courts.
Well, one big aspect of this is counsel. I mean, unfortunately, you have these cases go to trial where the prosecution is using some junk science, but the person on the other side that has no idea. They have no earthly idea. You take the person that Brian Stevenson represented in Alabama, who was convicted on this totally flimsy, totally discredited ballistic evidence. And yet, 30 years before finally the courts recognized that the defense lawyer was completely incompetent because he had no idea what was going on. He didn't retain an expert, a competent expert. He retained an incompetent expert. And as a result, you know, you have an innocent man sentenced to death. That's happening in Robertson's case. And there were all these bite mark cases for a while. Again, it's been totally discredited now in terms of evidence in these cases.
Yeah, I mean, as Steve said, I think that this is just another example of one of the fundamental principles and one of the fundamental themes in the book, which is that, you know, if you're accused of a crime falsely or correctly, what you need more than anything else is a good lawyer, which is why, you know, when we talk about solutions, the first one is always better, you know, enforcing the right to counsel. And this leads to, you know, a number of, you know, almost Kafkaesque issues, because, you know, on paper, if you don't have a competent lawyer at trial, that you can make a post-conviction claim of ineffective assistance of counsel. But enforcing your own right to a lawyer is almost impossible. I mean, you know, the first barrier to mention is that in the post-conviction process, you don't have the right to a lawyer. So you have to enforce your right to a lawyer at trial by yourself. And then, you know, as you know, Rebecca, when it comes time for appellate courts to review claims or habeas courts to review claims of ineffective assistance, the standards set by the Supreme Court are, well, they're extremely low from the standpoint of legal performance and extremely high from the standpoint of the person challenging their conviction. So, you know, on paper, we have a system that guarantees you the right to a lawyer and gives you recourse in case you were denied it at trial, but it breaks down on both fronts, both on the front line when it comes to your trial attorney, and then in the appellate courts when you try to enforce your right to a lawyer.
And how do we improve the jury system to make the process of selection and analysis of jury performance more fair?
Well, we talk a lot about that because that's the big issue in the country today, I think, is the fact that we still have all white juries. All these years after the Civil War, after disenfranchisement, and after all this unrepresentation in jury pools and all that, and that's still the same thing that's been used for years, which is prosecutors using their peremptory strikes to exclude people of color from serving on juries. And you go often to communities that had a very substantial, let's just say, African-American population, and you come in the courtroom and say, how could this be? There's not a single black person on the jury. And the reason is because the prosecutor struck all the African-Americans in jury selection. And the Supreme Court, after sort of sanctioning this for a while in a case called Swain versus Alabama, finally said, put an end to it in Batson versus Kentucky about 30 years ago. But the court totally undermined that decision by saying as long as the prosecutor can give a race-neutral reason, you can still strike all the blacks. And then it later said the reasons could be completely trivial because the person had a goatee or because they had an earring. Well, once you do that, of course, then the battle is lost because now you're asking these elected trial judges to decide whether a prosecutor before them who strikes all the blacks and says, well, I struck this because he had a goatee. I struck this one because he rolled his eyes. I struck this one because she looked nervous. And those are all upheld. So there you have it. We're right back to, as I said, we still have, after all these years, all white juries in these cases. Now, some things have been done about that. The state of Washington adopted an objective standard. Would a reasonable person, knowing all the circumstances, think race was a factor? That's been an important development. Arizona did away with peremptory strikes, the only state. Justice Brennan 30 years ago said we should do away with peremptory strikes. If you want to stop discrimination, you got to get rid of peremptory strikes. That's what it boils down to. And it didn't look like anybody was ever going to do it. And then 2 years ago, lo and behold, of all the states, who would have, I certainly wouldn't have put Arizona at the top of the list. But it's interesting because what Arizona did was they considered what Washington and California and Connecticut and a few other states have done about trying to figure it out under that objective standard. And they decided it's too woke. We don't want to try to figure out whether people are unconscious bias. We're just not going to let them strike. And that's going to put an end to it. And so we're now in the second year of Arizona not having peremptory strikes. It's going to be very interesting to look. The other thing we could do is just reduce the number to something like 2 or 3. Alabama, you sometimes have 20 peremptory strikes. So you can have a person on trial in a majority black county in Alabama tried by an all-white jury because the prosecutor strikes all the blacks in jury selection. So this is the fear of too much justice, the fear of dealing with race. I mean, that's what when Justice Brennan said that, was dealing with race and the death penalty. And there's still a real hesitancy to deal with race in jury selection and prosecutorial discretion in other areas.
One of the examples you gave that was just really striking was, I believe, a Pennsylvania, maybe Philadelphia office where prosecutors were told essentially just to put down some proxy for Black, Latino, and so that they could go back and provide a colorable reason later, essentially. And this led me, one of the points in the book I was a little dubious of. You say that the courts are essentially the most overtly racist system in America, that relative to other realms, racism is more obvious in the courts. I may be incorrectly paraphrasing, but I was curious how that comports with things like the work on the color of law and banking and financial institutions. And I was curious if it's just that we have transcripts and records, and as infrequent as they are, examples of trials and cases in which race is very explicitly mentioned as compared with these other arenas.
That's a good question. I mean, I think, racism has pernicious influence on many aspects of our society. And it would be a difficult question to say where it's has the most weight. I think that when we talk about overt racism, I think, if you look at, if we looked in banking or finance, there's very little on its face that would make you think this is a particularly racist industry. For example, even if some of the outcomes, if you look at, for example, who gets subprime loans, like in the financial crisis of 2007, 2008, there was pretty strong statistical evidence that people who were Black, all else being equal, were more likely to be sold subprime loans that were higher than they actually needed, with higher interest rates than they needed to pay. One thing I think that's striking about the courts in certain parts of the country is the extreme racial disparities in just who is in the room, literally, right? So if you look at the composition of the judiciary, you look at the composition of prosecutors, particularly at the district attorney level, one thing that, one picture we paint in one of the cases we talk about is, the unfortunate situation where the judge, the prosecutors, the defense attorneys, the jury are all white, the defendant is Black. And that's kind of a striking, it's a striking picture that you don't often see in society. Maybe it's just more overt than in some other cases. Also, if you look at the well-known disproportions in, prison and jail populations, these are, the disparities in representation of Black people in the criminal legal system go far beyond what you would expect from things like poverty levels, from income. So, And why could that be? I mean, I think a major reason is the widespread role of discretion in the criminal legal system. So the most obvious example is the prosecutors. Another example is sentencing. So to the extent that judges have discretion over sentencing, and as is well known, when you have discretion, it allows the injection of bias, whether it's conscious or unconscious. So the Supreme Court has said in various cases that discretion is fundamental, that prosecutorial discretion is so fundamental that we have to let prosecutors do what we want. We can't do things like the Supreme Court. If you go to federal court and you say, 57 people in this district were convicted of cocaine possession in the past 5 years. 56 of them were black. How can this possibly be constitutional? The Supreme Court will, as sure as day, is going to say, well, in every one of those cases, the prosecutor had a reason for prosecuting that person. So that is one reason why perhaps disparities, just gross disparities, persist that it would be hard to find in some other areas of society.
Well, in the Supreme Court in the McCluskey case basically looked at a sophisticated multiple regression analysis of sentencing in Georgia that in any other area of life would not be tolerable. And yet Justice Powell writes for the Supreme, excuse me?
I was just saying in housing and employment, areas like that, yeah, you could not have.
Right, and Justice Powell says, well, but this is criminal. And so he says, what is these disparities correlate with race, and it's inevitable that there are going to be these disparities. And then he also said, and this is a point we sort of make in our book, is that if we dealt with race disparities with the death penalty, we'd have to deal with race disparities with other kinds of sentencing because there are racial disparities throughout the whole criminal legal system. And that, of course, is what Justice Brennan in his dissent called the fear of too much justice. And I think he nailed it. And there are other cases where there's a jury selection case where the question was the lawyer for the accused, could you question the jurors about their racial attitudes? There were reasons to think that people on the jury pool were racist. And the trial judge didn't allow it. And Justice Powell, in another opinion, Rostanio versus Ross, said, well, no, if we start asking about race, then we're going to ask about ethnicity, and we're going to ask about all sorts of other things. This whole sort of slippery slope fear of too much justice. And I think the same thing in what we were talking about earlier about public defenders. I think there's a fear in a lot of places that if we had better resourced public defenders, and if we had the lawyers, the investigators, the social workers, and all the people it took to really provide people with representation, there'd be more trials, there'd be more acquittals, there'd be more justice than I think a lot of states, a lot of legislators, a lot of lawyers, prosecutors want. And so that's sort of our observation there. I think we could do better. We know we could do better, but we see some places which we point out where we do better. But unfortunately, in a lot of areas, there's this fear to do more to deal with race. The way Joseph Lowry, the president of the Southern Christian Leadership Conference, put it, he said that criminal justice system was the part of society least affected by the civil rights movement. That was his observation. I don't disagree with
that. We have a question from the audience. Have we thought about doing away with juries? Other countries don't use them, but use a panel of judges. And another question was, well, is a panel of judges more fair? So your thoughts on that?
Well, my own thought, for what it's worth, is that that would be the wrong direction to go in. I think, unfortunately, juries are becoming less and less. We just don't have many juries anymore, partly because of the plea bargaining we've talked about. But I think when you're in a lot of places, some crusty old hard judge, like James talked about a moment ago, that's looking for political points to be scored, these judge overrides that we see, I think juries are one of the great protections, particularly if you're an innocent person facing any criminal charge, if you're facing the death penalty. I think the juries, I think what we need to be doing is have juries that are more representative. and juries from which people of color and poor people and marginalized people are not excluded. Juries still are not very representative, because all the way through the process, summoning people to the courthouse, all these different places, people, don't get included. And so we ended up with juries that aren't very representative, racially or economically.
Well, and the flip side of that too, though, is when people are included, but face a much higher likelihood of discrimination or disadvantage as a result of choosing to participate on a jury, there's both selection bias and participation disparities, right?
Yes, exactly.
And
that's what we talked about with the use of peremptory strikes. I mean, in most jurisdictions, it differs state to state, but in most jurisdictions, once you have qualified a group of people to be on the jury, each side gets 10 strikes, say. As I said, in Alabama, it may even be more. It may be 20. I mean, there's this Lee versus Commissioner, a death penalty case in Alabama where the prosecutor struck 18 African Americans, and all the courts, state and federal, upheld it. Said there's a race neutral reason for every one of those strikes. If you really believe that, you probably would buy the Brooklyn Bridge tomorrow. It's just, pretty obvious what's going on there, but that happens all the time.
Well, and approaching the problem from another direction, you write about restorative justice, which I think is, a wonderful concept as you laid it out. You talked about studies, but not one that's necessarily commonly discussed, at law schools and the legal profession, or even within the social justice movement. So I was hoping you would expand on that and explain it as an alternative.
Yeah. So first of all, I think that, one of the issues when we talk about how society should respond to crime is that the prevailing mindset is that the response to crime should serve two purposes. So one is punishment. There's a I don't know if we should call it Puritan sense in this country, but there's a sense that if you've done something wrong, then you should suffer. And then I think there's a lot of fear, right? So the other main motivation in most people's minds for, let's call it, disposition of people who have done something bad is incapacitation. We want to lock them up so they can't do something again. And I think that, a social scientist would say, well, really what we should be thinking about is, what is the thing that will produce the best outcomes for the community going forward, right? And so, clearly locking somebody up for 25 years is not, for drug offenses is not something that really serves any particularly good value in the community. And getting back to restorative justice, so the principle of restorative justice is to try to meet the needs of the victim and the people close to the victim and the community, and to think about what is it that they want. And in some cases, what the victim and the community want is they want to know what happened and why it happened, and they want some assurance that it's not going to happen again. And so one of the core principles is to try to bring together the people who are involved in whatever bad thing happened, and find a resolution that will allow the community to move forward. And I'm not sure that it's the right tool to use in every situation, but what it reflects is the mindset that in the wake of a crime, what is most important is two things. One is healing, and one is reducing the factors that would lead to a similar crime to happen again, rather than our reflex being, making people suffer, which is a lot of what penal policy has been like since the 1970s. Basically policies that are designed to make life worse for inmates, such as getting rid of in-person visitation, for example, and just reflexive fear, which leads us to lock people up for much longer than any other kind of, rich democracy.
And I'm curious, obviously we're not talking about politics, but public opinion research right now seems to indicate both a lower approval level for the Supreme Court and a higher level of interest in the courts than we've seen in a very long time. And I was curious if you thought that there was a potential to harness public interest. And you alluded also to the podcasts and like Serial, where I think there's maybe growing awareness of the unjust aspects of our justice system paired with this higher level of interest in the institutions. Could we build on that? What are the most promising potential reforms or policies that might come of that?
Well, yes, and a podcast, be sure, I'd always mention in the Dark, season 2, which, as James mentioned a moment ago, is Curtis Flowers' case, and about their just remarkable race discrimination, which took place in jury selection over 6 capital trials. Just remarkable.
Yep.
And people need to understand that. One of the things that we point out, we talked a little bit about that earlier with juries, is that some things where the Supreme Court of the United States has not been very responsive, we have seen state Supreme Courts. We've certainly seen the state of Washington. The state of Washington Supreme Court looked at the same racial disparities that the United States Supreme Court looked at in the McCluskey case. And in Washington, they said this violates our state constitution. And they declared the death penalty unconstitutional in Washington, the state of Washington. Mm-hmm. And we've seen the same thing. The Connecticut Supreme Court declared the death penalty unconstitutional. We've seen the Arizona Supreme Court abolish. That was done not by legislature, but by the Arizona Supreme Court, abolish peremptory strikes. I know there are 50 states, so it's a somewhat exhausting task to think about. But I do think that there are a lot of things that we need to be looking to state courts and state Supreme Courts, state bar associations, state legislatures, because, unfortunately, the Supreme Court is in a very bad court and in a very bad place, and it's going to be a while before we get justice in some of these areas from that court.
And so you're giving wonderful examples of how some state level reforms or policies are leaders, but you also sort of mentioned that state courts are really also, maybe states have shown some of the best policies, but also some of the worst miscarriages of justice. And you talk about the discretion of federal courts to review state courts' decisions having been curtailed. So Alliance for Justice, of course, has both a state courts program and a federal courts program. And I think it would be of interest to hear your thoughts on the difference between sort of state justice systems and the federal justice system.
Yeah, so obviously there are many differences. I think, historically, one of the most important differences, I think, was that state, state trial judges are elected in most states, and state Supreme Court justices are either directly elected or stand for retention elections in a majority of states. Whereas, as we know, the federal judiciary is life tenure. And so for a long time, I think that the federal courts were a valuable backstop against miscarriages of justice in the state courts, basically because of the ability of habeas appeals in the federal courts. That backstop has been getting weaker and weaker, as you know, for two reasons. One is legislation, most notably the Anti-Terrorism and Effective Death Penalty Act, and then, but perhaps even more importantly than the act, a trail of Supreme Court decisions that has basically restricted the right to habeas corpus. The latest, wasn't there a circuit court that handed down a decision that saying that habeas corpus was only for cases of actual innocence? I don't know if that was...
Yeah, the Fifth Circuit, yeah.
Yeah. So
it would be the Fifth Circuit.
Yeah, so we've gotten to really a preposterous point in federal habeas corpus. And then, of course, we have, at the top of the federal court system is, of course, the Supreme Court, which has become increasingly, let's say, politicized, and it's increasingly hardline on these kinds of issues. So I do think, again, just to recap, I mean, historically, the federal courts were kind of a valid, they were a source of hope for people who had basically face a dead end in the state courts, that option has become narrower and narrower as time goes by. So I think, it's reached a point where certainly in a place like Washington, your chances of having your rights upheld are higher in state court than in federal court.
And it's one thing I would just say this. I said when they were talking about passing the Anti-Terrorism Act, I said, if you ever, destroy habeas corpus, it's sort of like dropping your precious crystal. Once it hits the floor and breaks into a million pieces, you're never going to put it back together again. I didn't anticipate that then the Supreme Court would come and sort of hypercharge what had already been done. But it makes it all the more important that people be competently represented at trials by competent lawyers, by public defenders and court-appointed lawyers, and that the resources, the independence of those be guaranteed, and that we build those up going forward. Because for a lot of people facing imprisonment or death, the important decision is not going to be made by 9 people in Washington. I'm sorry to say, it's only going to be they're going to come on the battlefield after the battle and shoot the wounded. What's really going to be important are 12 people from the community, and how the case is presented to 12 people in the community, and how the case is presented to the local prosecutor and the local judge. And that's got to be done by lawyers that do more than meet with a client for 15 or 20 seconds or 2 or 3 minutes before they plead guilty. We've got to have representation of people, and that's got to be done by public defender offices and by public interest legal projects and so forth, to really protect people's rights, because the federal courts are just not there anymore in almost any cases.
Yeah, I remember clerking on the First Circuit. I think the first case I was assigned was a habeas appeal or petition, and being shocked, despite a legal education and a prior clerkship, by exactly how impossible it was to get any kind of relief after the fact. So this would be, I could ask you another few hours of questions about legal education, what James has referred to as credentialism, which has recently risen to the fore, and how we create more public defenders. But I think this is the moment when I'm supposed to give you the opportunity to make final remarks. And thank you both again, as well as our audience, for joining.
Well, I would say one thing just that we haven't touched on that I usually get a question about, which is what about these so-called progressive prosecutors? And there are those who will say, well, they're not progressive enough. But I will just tell you this. I think that with regard to some of these issues we've talked about, race discrimination, but also prosecutorial discretion, you have someone like Larry Krasner who comes in and says, I'm not going to seek the death penalty at all. For somebody who's spent a lot of time trying death cases and representing people for 25 years in post-conviction, that's not a minor thing. The other thing, which I just say quickly, is the conviction integrity units. In a number of those offices have gotten a number of people. Again, it shows that the system is not getting the most fundamental thing right, but you've got offices that have gotten, like in Queens or Brooklyn, have gotten scores and scores of people who've been convicted out of prison by showing that they're absolutely innocent of whatever it was that they were convicted for. So that's not an unimportant thing. And I think it's really important that we pay attention to what happens going forward.
Yeah, I'd like to say, a lot of this conversation has probably been a downer. Of course, a lot of your audience is probably is aware of a lot of these issues already, so it's not new news for many of them. I'd like to say that one thing to bear in mind is there are thousands of people doing wonderful work across the country. The public defenders, all public defenders everywhere are dedicated to their jobs. Some offices have truly extraordinary people. Steve and I. One of our connections is through the Southern Center for Human Rights. Steve was the executive director for decades, and I was on the board for the past decade. And it's a wonderful organization in Atlanta that deals with death penalty, mass incarceration, criminalization of poverty issues. So, to the audience, I would say there are many people out there fighting the good fight. And so one, is there a source of hope? Another is if you're wondering what you can do, you could give money to one or more of these organizations. in general, the the nonprofit and public defender, criminal legal community, these are not overpaid people. they're not awash in donations, and they're doing lots of work on small budgets. So there are many ways to fight the fight. Politics is obviously another. I mean, a lot of these issues will require kind of systemic legislative solutions, and there are states where those are envisageable in the immediate future. There are states where they are not envisageable. But there are multiple fronts on which to fight on, and I would say the overall trend in this country is either neutral or mildly positive. I mean, obviously we have some serious political problems, and things could go either way. But on issues like wrongful convictions, death penalty, I think the public mood is moving in a slightly more progressive direction. So we can try to keep that going. And also, thanks very much for having us. It's been great.
Yes, thank you very much for having us.
No, we are delighted to have you. And on the note of something perhaps a little more positive and not the downer, I think that Alliance for Justice is especially excited by the measurable increase in diversity, certainly, especially among Article 3 judges over the last few years. And then trends in elections. So I'm thinking of Houston and of the Black Girl Magic slate of judges, African-American women who decided to run together. And I believe 17 were elected in just 1 year. And we talk a lot about both demographic and professional diversity. So I think I would encourage everyone, again, to acquire a copy of The Fear of Too Much Justice. And if you would like a positive moment, to check out some of the AFJ publications on the flip side of positive trends and increases in diversity among the judiciary. Thank you, Steve. Thank you, James. And thank you to our audience and your thoughtful questions. I'm sorry we're not able to get to every one of them, but we are very glad to have you here.
Thanks again.
Thank you. Take care.
You too.